procedure before we start the meeting. It's welcome to today's meeting, which is the Standards Committee panel hearing. Before we start the meeting, I would like to go through some domestic arrangements. Members of the public or of the committee may take photographs, film, audio, record the procedures. If you intend to make such a recording, could you please inform me now so that any necessary arrangements can be made and any potential disruption to the meeting can be avoided. I've noticed that you've all set up anyway, so thank you.
Who's recording on? Can we have clarification who's recording?
Minutes today.
Pardon?
BBC Minutes today.
Yeah. Right, it's Patrick Moreno, I'm just a local resident.
And Mr. Barnes,
I've already informed the chair.
you've already...
Yeah, just so everybody's aware who's recording, that's all, so it's open.
Okay. So the Council welcomes the greater rights now available to the public to report at meetings of the Council by filming, photographing or audio recording the procedures. A desk is available in the room within the public seating areas where you're all sitting to facilitate the recording. As chair of the meeting, it is my responsibility to ensure that these activities do not disrupt the proceedings. I would therefore request that the following rules are observed during any recording meeting, but ensuring that you do not move outside the areas of the designated for the public, cause excessive noise during recording, setting up or reciting equipment during the proceedings, use intrusive lighting or flash photography, ask for people to repeat statements for the process of recordings, provide any oral commentary or proceedings. Members of the public must also be aware that by entering the meeting room, they are using the public sitting area. You may also be filmed. Thank you for your cooperation. Now we go through the other. In the event of a fire, you will hear a constant siren. There are no planned practices today. If the fire alarm does sound, please exit calmly to the cenotaph, which is located. Please indicate direction from your location. Sorry about that way. If you go down out into the corridor, you can actually go through the double doors and across the road into the church. And please follow the officers who have organised this meeting today, which is Angela Garner. And please can all phones be switched off or on silent. The toilets are located in the crush oil, which is ladies that side, gents that side. 3 cups of water are available.
In the main reception.
In the main reception. When your item has been dealt with, please be free to leave. If you have any questions about this, please contact Member Services, and thank you for attending today. If we go to the agenda, and then actually after the closure of interest, I'll go through the orders of proceedings for you all. Okay. So apologies for absence.
Yes, Chair, we've had an apology from Councillor Ali. He has been replaced today by Councillor Hamer.
Number 2, disclosure of interests.
Yes, Chair. I know Councillor Shotton, and I also know his wife does some work for me with her firm, and I've been told by the legal department that makes me ineligible to sit on this committee. So I'm now withdrawing at this point.
Okay, thank you.
I'd like to declare that I know Paul Shotton on a professional basis as a member of the council.
Likewise, I'd like to declare the same, that I know him as a councillor.
I'd like to declare that I know Paul Shotton, obviously being a member of the Labour Party, cabinet member, and also know Paul Shotton, like everybody else.
Myself, because I'm a councillor. Okay, yes. Councillor. you. Okay, the order of proceedings today. First of all, we'll have, if I'll introduce everybody, I'm Chair, Councillor Anne James. On my left-hand side, I've got Councillor Shotton, Councillor Hamer. The independent person who we have is Mrs. Joan Carr. She's here on an advisory capacity. On my right-hand side, I've got Councillor Napper. We've also got our monitoring officer, which is Catherine Parkinson, and our democratic services representative here is Angela Garner, and we have Jerry Clark, who is the investigating officer. Okay. And the meeting is to determine an alleged breach of member code of conduct by Cllr Paul Shotton, and that's what we're here to discuss today. We've had notification, I think, that unfortunately...
Yeah, Councillor Shotton does not intend to appear today.
Yeah.
I'd like to move that we actually, because of expediency, that we actually carry on the committee in his absence.
For the same reason, I would like to second that proposal.
Okay.
Take a vote.
Can we take a vote? So, if we can actually, what will happen is, for your information, first of all, we'll hear the presentation of the case by the investigating officer. He will actually explain the nature of the complaints and put forward his investigation. The panel members can then ask relevant questions of the investigation officer. There will be a closing submission by ourselves, but what's happening is normally we ask people to leave the room, but when we're going to discuss the closing submission, actually what will happen is we will go into closed agenda, so we will be leaving the room instead of asking yourselves to leave the room. If that's okay with everybody. So then I hand it over to our officer, Jerry Clark, to present the evidence.
Thank you, Madam Chair. Madam Chair, members of the panel, the facts of this case are not in dispute. Over a period of 6 months commencing on the 19th of December 2013 and ending on the 29th of May 2014, Councillor Shotton sent 15 text messages under various aliases to a Radio Stoke debate programme in support of the council and its policies and criticising opposition councillors. The matter was first reported by the BBC and subsequently by the Evening Sentinel on the 29th of May 2014, and in an article headed City Deputy Paul Shotton suspended by Labour over phony text to Radio Stoke. At the time the matter was reported to the council, Councillor Shotton was the ward councillor for the Fenton East ward of the City Council. He was a cabinet member for economic development and he was Deputy Leader of the City Council. Councillor Shotton has admitted sending the text from his own personal mobile phone, and in the statement issued to the Sentinel on the 29th of May 2014, and which was reported in the article referred to, Councillor Shotton apologised fully for his actions. Madam Chair, you have within your pack a transcript of each of the texts, and those appear at Appendix 1, Document 1. As you can see, the texts fall broadly into 3 categories. Firstly, those that comment positively on City Council policies, such as the benefit of council housing over the private rented sector, the need for a HS2 station in Stoke-on-Trent, and the Council's decision to exhibit at Chelsea Flower Show. The second category of texts are those that comment negatively on the proposal for a town council for Fenton. And the third group of texts are those that comment negatively on opposition councillors and opposition policies. And at this point, in the absence of Councillor Shotton has quite correctly identified that there is no direct criticism of opposition policies within the text, and so therefore paragraph C should be amended to read those that comment negatively on opposition councillors rather than opposition councillors and opposition policies. Turning to the relevant legislation and the provisions within the code, the Localism Act 2011 introduced fundamental changes to the regulations of standards of conduct for elected and co-opted members. Under section 27 of the Act, a relevant authority of which the Council is one must promote and maintain high standards of conduct by its members and co-opted members, and when discharging its duty, adopt a voluntary code dealing with the conduct that is expected of members and co-opted members of the authority when they are acting in a capacity as members, that is, when they are acting in an official capacity. At its meeting of the 27th of July 2012, the Council adopted a revised Members' Code, and the relevant provisions are set out in paragraphs 2.6 to 2.10 of my report, and I'll briefly summarise those. Paragraph 1 of the Code makes it clear that the Code applies to all members of the authority, and paragraph 2 of the Code makes it clear that the Code applies whenever members act in their official capacity. That is, when members conduct the business of the authority, which includes the business of the office which the member is elected or appointed, or they act, claim to act, or give the impression that they are acting as a representative of the authority. I think key to this investigation is that the Code does not have effect in relation to conduct undertaken by a member in a purely private capacity, unless that activity has a link with the functions of the member's office. Therefore, in order for there to be a breach of the Code, a member must be acting in an official capacity. The first issue I therefore must have considered and must determine and this panel must determine, is whether Councillor Shotton was acting in an official capacity when he sent the text to Radio Stoke. This is a complicated area of law, and the High Court considered the matters that could be covered by the Code in October 2016 in the case of Livingstone versus the Adjudication Panel for England. In this case, the Mayor of London, Ken Livingstone, had been referred to the adjudication panel by an ethical standards officer over comments he made to an Evening Standard journalist after a dinner. The ESO alleged that Mr Livingstone had been in breach of the equivalent provisions to paragraph 5 of the Council's Code, and a member must not act in his official capacity or in any other circumstance conduct himself in a manner which could reasonably be regarded as bringing his office or authority into disrepute. The panel found that while Mr Livingstone was not acting in an official capacity, he had breached that provision. In the High Court, Mr Livingstone argued that the effect of section 52 of the Local Government Act 2000, which is the duty to comply with the Code of Conduct, was to prevent the Code from covering activities which were carried out in a member's private life. Mr Justice Collins found that whilst the Code of Conduct could extend to a member's acts outside an official capacity, those acts had to be in performing his functions, and any other circumstances in that case was to be construed narrowly. The law has developed since the Livingstone case, and in the case of Banbrook, full statements have been made by a councillor in a video which were posted on the internet. In this case, the tribunal found the video to be a party broadcast, and in relation to the question of whether the appellant in that case was conducting the business of the authority, it referred to the judgment of Mr Justice Charles in Mullaney versus the Adjudication Power for England. In that case, it was stated, and it's a key test, the most relevant part of the definition here is conducts the business of the office to which he or she has been elected or appointed. These are ordinary descriptive English words. Their application is inevitably fact-sensitive, and so whether or not a person is acting inevitably calls for informed judgment by reference to the facts of a given case. This also means that there is potential for two decision makers both taking the correct approach to reach different decisions. And I said that's a key decision insofar as you are to apply the tests set out in the case against the facts of the case. Further guidance can now be found in a further judgment in MC versus Standards Committee of the London Borough of Richmond. In that case, which concerned a member sending out emails, Mr Justice Ward said, the test under paragraph 21A in the particular code is whether the appellant was a matter in the ordinary course of English language actually conducting the business of the authority, including the business of the office to which he'd been appointed. Further, when one is acting as a representative of the authority is therefore a matter for determination by the tribunal of fact, in this case the Standards Committee, or on appeal in the first tier tribunal. I do, however, consider that reading the model code as a whole, it's evident that representative is not to be equated to member. The model code uses both terms and must be taken to have done so deliberately. Accordingly, merely to act, claim to act, or give the impression that one is acting as a member is, in Mr Justice Ward's view, not of itself sufficient unless there is material on which the tribunal of fact can properly conclude that the member was acting as a representative of the authority. I realise that that is a particularly but important series of judgments. Paraphrasing, the question therefore properly be construed as being, was Councillor Shotton conducting the business of the authority or acting as a representative of the authority when he sent the text to Radio Stoke? As I previously said, the text can be broadly grouped into three types. Those that comment positively on council business, those that comment negatively on the proposal for a town council for Fenton, and those that comment negatively on opposition councillors. There's no doubt in my mind that had Councillor Shotton sent the text in his own name, he would have been perceived by listeners to the Radio Stoke programme to have been representing the authority as a senior member of the Cabinet and as Deputy Leader of the Council. However, there is an important but subtle distinction between the public perception of when a member is acting in an official capacity and when in fact in law the member is actually acting in an official capacity. Text of the type referred to in paragraph 4.8a, i.e. those that relate directly to council business, as I said, relate specifically to decisions taken by the authority, all of which Councillor Shotton have been involved in, either as a spokesman for the council or as part of the Cabinet. And it's clear to me that under the principle of collective Cabinet responsibility, the functions of a council Cabinet member include the promotion and defence of the council and its policies and its decisions. I'm therefore of the opinion that if Councillor Shotton had sent the texts, those type of texts, in his own name to the Radio Stoke programme, there would be no doubt he would have been perceived by the general public and in fact in law acting in an official capacity. Text of the type referred to in paragraph 4.8b, i.e. those commenting negatively on the proposal for Fenton Town Council, are more problematic in that they do not specifically promote or defend council policies or council decisions or any decision previously taken by the authority. Councillor Shotton has helpfully referred me to the case of Ben Grower, a Bournemouth councillor who in 2009 had posted comments praising himself and fellow councillors on a local newspaper website under the pseudonym Amiga Man. In this case, the Standards Board for England found that Councillor Grower was not acting in an official capacity and the Code of Conduct did not apply. In its decision letter, Standards for England stated, in writing under another name for a newspaper, Councillor Grower was not conducting the business of the authority or his office. The Code applies to members when they conduct the business of their authority. Madam Chair and members of the panel, I find this decision entirely consistent with the decisions of Mr Justice Charles in Mullaney and Mr Justice Ward in the London Borough of Richmond. Following the decision in the Richmond case, Standards for England issued a statement to the effect that decisions could have significant ramifications for members when they undertake activity on blogs, Twitter and other internet sites. And in that statement they stated, it is unlikely that most blogs or etc. postings will contain content that holds a member out to be acting as a representative of the authority rather than simply as a member, unless that content in some way gives the impression that the member is speaking for the council. However, depending on the circumstances, such communications might be regarded as conducting the business of the authority or of the office of the member. This is because it is reasonable to regard communicating with constituents at large about issues of local political interest as being part of the business of the office of a councillor. Chair, I'm firmly of the view that the ongoing governance review and the proposal for a town council for Fenton is an issue of local political interest, and on balance, by commenting upon it, Councillor Shotton would, if he'd sent the text in his own name as the local ward councillor, have been acting in an official capacity. Text of the type referred to in paragraph 4.8c, i.e. those criticising opposition councillors, do not relate specifically to the council's policies or to decisions previously taken by the authority, nor can they be construed as communications with constituents at large about matters of local political interest, and therefore on balance I do not believe that the texts referred to in paragraph 4.8c above fall within the remit of the Code of Conduct. Having come to this conclusion, I must now consider whether by sending texts of the types referred to in paragraphs A and B, i.e. those which relate to council business or to matters of local political interest, under various aliases from his private mobile phone, does this mean that Councillor Shotton was no longer acting in an official capacity? And in his defence, Councillor Shotton argues the use locally of pseudonyms is very prolific on local blog sites and the main newspaper sites. Virtually all posters post under an alias or a pseudonym. I agree with Councillor Shotton that the use of aliases or pseudonyms is common and in certain cases appropriate. However, it's usually apparent when such aliases or pseudonyms are being used. In the circumstances, I do not consider that the use of an alias or a pseudonym by a member of the council's executive to comment on council policies or council business would have been or is appropriate. To accept such an argument would mean that members would be able to act with impunity and to breach the Code of Conduct without fear of recourse. Finally, on this point, I do not consider that the fact that texts were sent by Councillor Shotton from his private mobile phone to be material. It's well established that official information held in private email accounts or in text on private mobile phones may be the subject of disclosure requirements of the Freedom of Information Act if it relates to the business of the authority. Having concluded that Councillor Shotton was acting in an official capacity when he sent the text to the Radio Stoke, I must now consider the content of the individual texts and whether the content of any of the text is defamatory, disrespectful or otherwise in breach of the code. As I stated previously, the texts support council policies and its decisions and oppose or criticise opposition councillors. This, in my opinion, is the normal course of business of a local authority. Having considered the content of the text, I do not consider that the content of any of them is either defamatory, disrespectful or otherwise in breach of the code. Councillor Conway, the complainant, disagrees with my interpretation and believes that one of the texts in particular has damaged his reputation as Leader of the Opposition. The text in question was sent on the 21st of March 2014 and states, "Can't believe Councillor Dave Conway, where do we get these people?" The text was sent anonymously. For the reasons set out previously in my report, on balance, I do not believe that when Councillor Shotton sent this text, he was acting in an official capacity, and therefore, hypothetically speaking, even if the content of the text had damaged Councillor Conway's reputation, which I do not believe it does, it would fall outside the remit of the Code of Conduct. Finally, having concluded that Councillor Shotton was acting in an official capacity when he sent certain of the texts, but that the content of those texts are not defamatory, disrespectful, or breach the Code of Conduct, I must now consider whether by sending those texts under various aliases, Councillor Shotton could reasonably be regarded as bringing his office or authority into disrepute. In deciding whether the misconduct complained of is reasonably regarded as bringing his office or authority into disrepute, it is not sufficient simply for the misconduct to damage the reputation of the individual. At the time Councillor Shotton sent the text, he was Cabinet Member for Economic Development and the Deputy Leader of the Council. At all material times, Councillor Shotton held a very senior position within the authority, and as such his conduct was under very considerable scrutiny. In his defence, Councillor Shotton states that his motivation for sending these texts was the incessant negativity demonstrated by local media generally, which appears to be constantly trying to present and perpetuate a negative image of the city and in particular the City Council. He further states that it was not his intention to mislead the listeners of the Radio Stoke programme, just to present what he believed to be a balanced view and a more positive perspective of the city and the City Council. I must say at this point I have some sympathy for Councillor Shotton, and I can understand his and other council colleagues' frustration in getting their point and their message over to the public. However, regrettably, I am of the opinion that despite his intentions, his actions did mislead the public, who may have had a different view on the matters had Councillor Shotton sent the text in his own name. Accordingly, I am of the opinion that in sending the text to Radio Stoke under various aliases, Councillor Shotton has not only damaged his own reputation, he has damaged the reputation of the Cabinet on which he served and the position of Deputy Leader of the Council. And for the reasons above, I find that in this instance, the complaint made by Councillor Conway is upheld in part, and that Councillor Shotton's actions have brought both his office and the authority into disrepute. Madam Chair, unless you have any questions.
Thank you. Councillor John.
Yeah. In your statement, Jerry, you say it's a personal mobile phone. Now, I mean, I have my own personal mobile phone, which I use for council business as well as private business, and I get an allowance for that phone. which to me makes it, how can I say, an official phone, while I'm using that phone, if I'm using it for anything to do with the council. Does Councillor Shotton have a separate phone that is supplied by the council, or like me, as an allowance for that phone?
I'm not aware of that, Councillor Dutton. I couldn't say either way. I don't know.
Councillor Napper.
Jared, I think it's a very thin line. Obviously 4.19, you say you conclude that Councillor Shotton was acting in an official capacity, but from the authority's perspective, was he acting in an official capacity, or is it perception that, you know, from the public's eyes, he was acting in that capacity? Because obviously, you know, it's dividing if he was acting on behalf of the authority or acting on his own instincts, or it's the perception what people would get, wouldn't it? Because I think there's a define between the two, isn't there, really?
Councillor Napper, the only thing I can say in that is that I have tried to set out in the report the legal tests to be applied to determine whether or not a member is acting in an official capacity. And as I said early in the report, it is fact sensitive. There is a fine line between when a member is acting in an official capacity and when they're acting in a purely personal capacity. In my view and in my opinion and my analysis, at the times that Councillor Shotton sent the texts, he was acting in an official capacity as the legal test applies to those type of texts relating to council business and to local political interest.
Yeah, I understand that, but what I'm trying to get at is what he was saying is not an official statement from the authority. There's a separate sort of line. It's difficult to determine it because it's not, what he's saying is not official of what, you know, he was doing that on his own, but obviously perceived.
I think when members accept the office of councillor, there are two things. Firstly, do the public perceive them to be making statements on behalf of the authority? And secondly, is that member actually representing the authority at the time they made the texts? And I said earlier in my report there's a subtle distinction between the two. In my view and in my analysis, there is a fine line, but unfortunately when you apply the tests set out in the report, in my opinion, Councillor Shotton was acting in an official capacity.
Okay, thank you, Joe. I think you clarified. Thank you.
Thank you.
Councillor Home.
Thank you. Thank you, Jerry. It is noted in your report that the use of pseudonyms by a member of the Council's executive, specifically to comment on council policies or business, to be inappropriate. Your report also notes that the texts under question are not defamatory or disrespectful or otherwise in breach of the Code of Conduct. That's a direct quote from the report. I'd like to know specifically whether the Bournemouth case, the recent case on the 2nd of September, is substantively different from this case, and if so, in what way?
In the Bournemouth case, which unfortunately, I suppose fortunately for Councillor Grower, but unfortunately for lawyers, did not go to the High Court. It was not appealed. So all we have is the decision letter from the Standards Board. And in that particular case, there is a clear distinction between messages and texts and blogs which effectively praise a member and praise the work of that member, or even go so far as being a political campaign is concerned, or party political campaign is concerned. And in those cases, I feel it's quite right. Those are not members acting in their official capacity. What you have to do is link the the subject matter to the business of the authority. And in that particular case, Councillor Grove was not conducting the business of the authority. He was merely praising himself and his fellow councillors.
Okay. Any other questions?
Yes, briefly, just a question regarding what could be considered as a value judgment. Specifically, the report states that it is well established that official information held in private email accounts or in text or on private mobile phones may be subject to disclosure requirements. I think it may be clear to lawyers and perhaps a number of us in this room and indeed some others, but I don't think it necessarily is the case that it is well established to all lay people, and I include lay people who may be councillors.
I absolutely agree, and I probably use lawyers' terminology in that respect. It's a well-established fact of law,
Yes.
or a principle of law.
Thank you.
Thank you.
Can I just ask a question? Has actually Councillor Shotton actually undertaken training under the standards?
All members receive or are offered training. I can't specifically say whether or not Councillor Shotton has undertaken this standards training, but it is offered to all. Angela, could you help on that?
Unfortunately, no, Chair. It isn't our team who actually deal with the training.
I think on previous meetings we have had reports that everyone is supposed to have undertaken the training.
It is offered to everyone.
Yeah. No other questions? No? Thank you very much for the report. I appreciate all the hard work that actually you've undertaken on our behalf. What we will do now is actually retire and actually into the other room and discuss actually the report.
Thank you.
Do you want to make any closing submission before we go
No,
and
Chair,
make a
thank you.
decision?
No, I think.
No. But thank you very much for your report. It's very much appreciated.
Thank you.
Thank you.
Thank you.
Okay. I'm going to read out the findings. I'd like it noted that actually it was a unanimous decision by the panel that, having heard the evidence presented by the investigating officer and read the submissions of Cllr Paul Shotton, the panel have determined that the complaint made by Councillor Conway is upheld in part. Councillor Shotton's actions could be perceived as acting in an official capacity and could be reasonably regarded as bringing his office or authority into disrepute. Before we go any further, can I invite the investigation officer, if you've got any other comments that you would like to make, please.
I have no comments in respect of your decision. You're inviting me to comment on a proposed sanction.
Yes, please.
You've been advised of the range of sanctions that you have and that you can impose as a panel. Personally and professionally, I believe that Councillor Shotton has paid an extremely high price for his actions, which he has stated were meant with the best intention. In that respect, I believe that Councillor Shotton's misdemeanours fall within the bottom range of the possible sanctions that you could impose. And to that extent, I would consider a reprimand or a censure as being an appropriate sanction. And possibly the a further referral for additional training.
According to the procedure, this is where we actually leave the room again and we discuss actually what's been proposed. Okay.
I think it was a lady.
Okay, it's been agreed that the sanctions that are available to the panel. I don't know if you've all got a copy of what sanctions we can take. Okay. Number one is censure and reprimand the member. We have to publish the findings in respect of the member's conduct, and a report of the findings will go to the council for information. And it's been recommended by the panel that a recommendation to the leader that the member holds no chair or cabinet position for the remainder of the municipal year. We're also instructing the monitoring officer to arrange training for the member, and that is more or less all the powers that we've got as a committee that we can actually impose. So you will get a full report of the findings will actually be published, and we just thank everybody for attending.